because you did not have a guilty mind, even though you had a guilty act. So this is something that makes sense to all of us. You kind of need to be aware that you're doing something before you're held responsible for that action. So we say that liability arises when when two conditions are met. Both there is actus reus and mens rea, meaning that you had a guilty mind and you took at least some action towards uh, towards realizing the intention that you had. Jim, feel free to jump in anytime you think I'm incorrect. So mens rea has different states, and in most areas of law, we recognize at least four states of mind for committing an action. Actions could be either intentionally, knowingly, recklessly, or negligently. Intentionally, I grab my gun. I say, I'm going to kill Jim. I aim the gun at Jim and I fire. That is an intentional act. Knowingly is there is a fly on the wall. I grab my gun to shoot the fly, but Jim's in the way. And so I know that if I shoot the fly, the bullet will go through Jim. I'm not intending to kill Jim. I'm intending to kill the fly, but I know that Jim will be shot. So that's knowingly. Recklessly is there's a fly buzzing around. I grab my gun and I start shooting, and I don't give a diddly do about who's around, if anybody else is going to get injured or not. I'm totally reckless. Negligently means I didn't exercise enough caution. I didn't want to hurt anybody. I was trying to be as careful as I can, but I didn't know how to be really careful, or I took a shortcut or something like that, and the gun went off. So that's negligent. So these are different different laws have different states requirements for mens rea. So, for example, murder in the first degree has to be intentional, but unintentional homicide could be, or unintentional manslaughter could be negligent or reckless. So different states of mind have to be present. So, for example, we've seen this, that the defendant was not convicted of first degree or second degree homicide, but was convicted of manslaughter. Well, why is that? It's because the prosecutor couldn't show that the act of manslaughter was intentional or knowing. And so the best they could do was that it was negligent or reckless. So the jury says there was no evidence, or not evidence beyond a reasonable doubt, for intentionally doing this, but there was evidence beyond a reasonable doubt that he negligently do that. So the defendant gets convicted of the lower charge. Anyway, why are we talking about this? Besides that, I like to hear myself talk, is because on slide 7, the statute gives us the mens rea for misappropriation. We see in the highlighted sections that at the time of disclosure or use, knew or had reason to know. So this is the mens rea for misappropriation of trade secrets is knowingly, meaning that if you're misappropriating it, you need to knowingly misappropriate that. And so we go talk about whether they uh, knowingly acquired it, and the answer is no, they didn't. They bought a piece of software from CSI, and they didn't know that Silvaco had written a part of that. So you can't acquire something inadvertently. That is the as it says, uh, the term implies conduct directed to that objective, meaning that you were knowingly trying to acquire Silvaco's software. Intel was. Well, Intel didn't know this existed, so you can't acquire it if you don't know it exists. And one who passively receives a trade secret but neither discloses nor uses it is not guilty of misappropriation. Why? Because there was no actus reus in this area. Even though you knowingly received it, but you didn't do anything with it, you didn't take any steps in towards misappropriating it, you have not misappropriated it. And my conclusion is that you can manipulate something that you have not acquired, and you can't acquire something that you don't know you have acquired. Knowledge is the same way too. If you know something, that means you have information about it. Intel didn't have any information about CSI, so sorry, Silvaco's software. So there was no misappropriation. There was no misappropriation because the knowledge requirement uh, was not met. Jim, do you have anything to add to this? Anybody has any questions? All right. Wait, if you steal it at gunpoint and bribe judges, I think you know the answer to that question. All right, so we go to the next case, Omega Optical v. Chroma Technology, Vermont Supreme Court. I'm not going to go through the details of this case. I'm just going to give you the evidence that the court used to say that Omega did not exercise reasonable efforts to maintain this secrecy, is that they didn't have a written policy on confidentiality. That is the biggest no-no you can have. Then the company recognized they needed to do that, but they were trying to put together a program to teach people, but they hadn't done that yet. There was very little awareness among employees as to what is proprietary, what is not, what is confidential, what is not. And record keeping was sloppy and decentralized, meaning that people could access all kinds of records, people of all kinds of backgrounds and job descriptions could access all kinds of records. So access was not limited on a need to know basis. So all of that led to uh, the the uh, the defendants who were ex-employees and left and used all of this confidential information to set up their own business, they had not misappropriated trade secrets because the information that they stole wouldn't have qualified as trade secret because it was not subject to reasonable efforts. The people who left Omega, uh, where ex-employees, sorry, the people who set up Chroma, the defendant here, were ex-employees of Omega. And so, what kind of responsibility do employees and former employees have towards the proprietary information of their employer? If you're an at-will employee, you may plan to compete with your employer, meaning that you can go ahead and set up your company, you can put together your board of directors, you can get your licenses to whatever technology you need, right? You can do all of those, but you can't actually compete. But you may freely compete once you leave that company. So that is the law basically everywhere, and it's because we already have laws against misappropriation of trade secrets. If we have those laws, then we don't need to restrict at-will employees' future employment on trade secret basis. We're already constraining them using regular trade secret misappropriation laws. If they have misappropriated, then go ahead and sue them on that, but you can't proactively prevent them from competitions. And that's because at-will employees have no duty of loyalty to their employers. Why don't they have that? Because the employer doesn't have a duty of loyalty to that employee, and that falls out of the definition of being an at-will employee. If you have a duty of loyalty, then you wouldn't be at will. Okay, that's all I wanted to say about Omega v. Chroma. Hi, Plutos. Welcome to the stage. Do you have a question? All right.
Hey Sam, before you go on, so this is a Vermont case, but you said this law applies everywhere?
It is followed by many other states. So even though it's a Vermont case, it's not an outlier. It's
Okay,
within the corpus of the other states' jurisprudence.
very good.
Okay. Oh, I have sound issues. Uh, do I have sound issues, or is it just Pluto's? If
I hear you loud and clear.
okay, sounds good. All right, next case is the last case for today, but I think it's a very very interesting case because PepsiCo v. Redmond. It's very interesting because this is the case that sets off the whole battle over non-compete agreements nationally. And we'll see how two different states, California and Utah, took the decisions of this court and similar courts in their statutes. So Redmond works for PepsiCo, uh, and he was high up in the marketing department of PepsiCo, and then so he knew basically everything there is to know about PepsiCo's marketing plans and for the next 2 or 3 years. He quits PepsiCo and goes to work for Quaker. And what drink does Quaker make? Snapple. So he becomes one of the top people in the marketing department for for Snapple. He does some weird things which are kind of they don't smell too good. PepsiCo asks him, "Hey, are you looking for another job?" He says, "No, I'm not." Even though he was interviewing with Quaker. Then he had accepted his offer from Quaker. PepsiCo asked him about it. He said, "No, no, 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 there's no offer. I haven't accepted anything." But then he left. And so PepsiCo became very suspicious, naturally. It's like, what the hell? And sued under the theory of inevitable disclosure. They said that Redmond, we'll talk about what inevitable disclosure is on the next slide, that you would inevitably disclose your information. Redmond said no. They already have their marketing plan. I'm not there to come up with a marketing plan. My duties are only to implement the marketing plan that that they have. And also, I have an NDA signed with PepsiCo and a confidentiality agreement signed with Quaker that says I will not disclose the trade secrets of others in doing my duty. So he argued that there is no actual or inevitable disclosure of the trade secret. So what is inevitable disclosure on slide 14? It is basically the third bullet point. A person assumed a similar position at a competitor make it inevitable that the person will use or disclose trade secret information. So inevitable disclosure says, by virtue of the fact that he has this position at a competitor's company, he will be disclosing our trade secrets. There's no other way. If he's going to deal with the marketing plan of Quaker, he will use information that he gleaned from PepsiCo while he was their marketing people. So the court here said, well, you're trying to prevent not the actual misappropriation, but the threat of it. Because it's a threat of it, this is not a ripe case. Nothing bad has happened yet. And you're trying to prevent this person, Redmond, from exercising his freedom to pursue happiness. And you can't do that. So unless there is actual misappropriation, or there is such a high degree of probability that it will inevitably and immediately use the trade secrets, then you can't stop them from taking that new position. And so here they said the threat was that all of the plans in terms of distribution, packaging, pricing, and marketing moves had already been figured out. He was just going to implement them. So there was no inevitable disclosure, and so Redmond could go ahead and pursue his career at Quaker. Jim, did that make sense? What I said, was it
Yep.
clear? Okay.
Yeah, but I was just, so it's inevitable. So what I'm curious to see what you talk about next is the tension between being able to have a job and being exposed to the secret sauce.
Yeah.
Okay.
So we go to slide 15, and we used to have these things called non-compete agreements, meaning that when you were leaving your position, you would sign a paper that says, okay, I won't compete with my former employer at my new employer's place. So these are not legal in California, Oklahoma, and North Dakota at all. Other states limit them, uh, but they limit them to the point that you might as well say they don't have non-compete agreements. So let's see what California does with this, and then we look at how Utah treated this to see the two differences. In Utah, in California, it's actually the legislature tells us every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. So you cannot limit people from engaging in a lawful profession, trade, or business of any kind. Every individual possesses, as a form of property, the right to pursue any calling, business, or profession they may choose. So the emphasis here, so first of all, the public policy in California is unlimited employee mobility and freedom. So how does California deal with former employees disclosing misappropriating trade secrets? It says lawful profession, traders, business. Misappropriation of trade secrets is not a lawful act in a profession, trade, or business, and so therefore you can go after them. You can have a contract that says, "Do not disclose my trade secrets." You could have that, and then if you violate that, then it's going to be an unlawful act, and 16600 then don't apply. But look, you haven't you haven't restrained them from pursuing a profession. You have only restrained them from disclosing your trade secrets. They could still have that job if there's no inevitable disclosure or actual disclosure. Hi, Plutos. Are you connecting? Okay, maybe not. So we now look at how Utah does this. So in California, no non-competes, right? From out the door, they're unlawful. In Utah, they're lawful, but it has to be for a maximum of just 1 year. Can't be longer than that. It has to be limited to a reasonable geographic area. So basically, if I work for a company in Salt Lake who makes widgets and sells them in Salt Lake, I can go to Denver and work for a competitor who makes and sells widgets in Denver because they're not competing in the same geographical area. So I can go compete in a different geographical area. And that limitation has to be reasonable. And reasonableness here has to do with the reach of the market for where you are. And it has to be, in terms of scope of the information, also very limited. That is, it protects only legitimate business interests of the employer. Utah courts have kind of interpreted that through many cases to say legitimate business interests include IP, business plans, financial information, customer lists, referral sources, goodwill, customer relationships, and employee training. So note that if you're a mechanical engineer and you're working for a company and you're using information that you didn't gain by training through your employer, this is the information that you came in with, you can go ahead and use that information anywhere else because you didn't gain them by employee training. We had the case of the oil fields in South Dakota that dealt exactly with that issue. So we see that a lot of different states have these limitations. So in Utah, what are the factors that you use to do this? Courts love to come up with factors because this tells them how to analyze cases, tells us attorneys how to present cases, and how to attack cases. So factors are there are 8 factors you need to consider in Utah. Are you competing? What is the scope of your new job? Was the employee less than candid about his new position? Plaintiff clearly identified traits. You can read them. So it's basically you need to go through a whole bunch of song and dance to prove a competition that has to be enjoined. And by the time you do this, you end up with your non-compete agreement not being enforced. So even though the law says they're enforceable under these conditions, most courts in Utah do their darndest to take the case out of those conditions and say that non-compete agreements are not enforceable. Well, this concludes what I wanted to say today. I'm going to introduce a new feature for my rooms, and that's called musical interlude. So when the actual lecture is over and the QA starts in between, I'm gonna play a song because I drink a lot of coffee. And so now is the time for that musical interlude. Come on up. It's going to be less than 4 minutes.
Hey,
The
Sam,
Hound.
can
Yeah,
we
yeah, yeah.
can we not? Can we not? Because we're live on YouTube in these rooms, and if you do that, we're gonna get a copyright strike. So if you
Therefore,
want to play some music, if you want to play some music, you can play the things that are on YouTube under free for use, like not licensed, or you can play the music that is on Clubhouse already. But if you're gonna play one of your liked songs, then we're gonna get a strike, and I cannot cut it because it's in the middle of the episode.
no, no,
Usually
no.
at the end, I
Yeah,
cut
yeah.
it and I move on.
I totally understand that, being an IP attorney. So I will not play music. So you guys talk amongst yourselves
I can
for.
play one of I can play a song like one of the free ones, like the available. They're nice. If you want a break, I can totally do that.
Please do that. Yeah.
Okay. Okay. Can you get the other profile, like the Logic guy, up, and I'll do it.
Well, I reinstalled the app, which I've never had to do before. So it looks like sound's working finally.
So I'm back. If you...
That's
Thank
it.
you very much. Go ahead, Shamash.
Oh, no, I was just asking if you want to resume or should I keep playing the music?
Let's resume. And this is Q&A, conversations, whatever. So Plutos, Shamash, Jim, and people in the audience, you can raise your hand and come up here. Yeah, Chinga, I don't have very strong emotions towards South Dakota, so I know you do.
Well, I was gonna, before I had to reinstall the app, so I missed some of it. I was gonna say, something to the point of, like given the FTC's ban on, non-compete agreements, because I'm in California as well. How do you see the, courts adapting, you know, the inevitable, disclosure doctrine, from PepsiCo's, Red Bund and to fill the gap, left by you know unforceable non-competes. I think that was something like my question, if that's still relevant.
So in PepsiCo and subsequent cases, both in California, I can't really speak as to the elsewhere. In California, they say you basically deal with that there is no such thing as inevitable disclosure. You have to show actual disclosure, or you have to show the probability of inevitability is really high and the relevance of the information is really high in order for us to recognize misappropriation of trade secrets under inevitable disclosure. So the courts didn't say that there is no doctrine of inevitable disclosure. What they're saying is that it's very difficult for you to fit your case under that doctrine, but if you can, then more power to you. So in all of these states, it's just a straightforward trade secret misappropriation, and sometimes with a dash of inevitable disclosure thrown in to to kind of capture inevitable disclosures. Did that answer your question?
I think so. Yeah, I'm not the best at this, but does that is that saying California should like reconsider its rejection of the
No, no, no,
uh
no,
oh
no. My thing is that the approach that that California has taken is the correct approach, in that you do not restrict competition, you restrict misappropriation of trade secrets. So if the employee is going to leave and compete with you, but not disclose your trade secrets, then they should do that. And then the assumption is that the employee is not going to disclose your trade secrets unless you can show through the difficult task of inevitable disclosure that the employee will inevitably disclose. So the courts have made it very difficult for inevitable disclosure to be used to prevent someone from moving. Do you agree, Jim? If you're listening.
Sorry, I was on mute. Yes, it pains me to say yes, I agree.
Yeah, awesome.
So
Oh yeah, go ahead.
from a practical standpoint, I mean, you're a business owner and you have a trade secret, and it's the heart of your business. How do you keep people? How do you keep former employees from misappropriating that? You have to train them so they get to know the secret sauce. You can't keep them from going to your competitor. So how do you control the flow of that information?
Are you arguing inevitable disclosure?
Kinda.
So then the burden is on you to prove that their job descriptions were the same, they were going to make the same decisions, the information that goes into their decisions are information that can only be obtained through them having worked at your place. You know, so you could. I mean, this is what the conclusion of all these cases is that you could sue on inevitable disclosure. I mean, the court here says threatened misappropriation can be enjoined where there is a high degree of probability of inevitable and immediate use of trade secrets. So we still have that tool,
Mm-hmm.
but the burden is on you to show that there's a high probability of inevitable and immediate use of the trade secret.
Wow, good answer. Yeah, that actually makes sense to me from a policy standpoint. Yep.
Yeah.
So, and this situation's in stark contrast to employment laws, my understanding, the law according to Jim, in Europe, where you can have and regularly do have restraints on folks um, once they leave one company and go to another.
You sound like you're sitting in the middle of the Garden of Eden
I
with
am actually.
all the birds tweeting about you. Anyway, I'm not familiar with the European Union labor laws, so
So there was, I had a foreign associate. I was working with a UK patent attorney, and she left one firm to go to another. And there was a legal injunction on her going after her former clients because of a non-compete agreement.
yeah, we don't have that. We don't have that here, right? I mean, while I'm a partner at the firm and I'm gonna go to another firm, while I'm a partner, I can call current clients of the firm and say, dude, I'm leaving, I'm going to this firm. I cannot do that. But once I leave, I can call anybody I want.
And is that, leading question, and is that a trade secret issue?
Yes,
No,
it is.
no, it's not.
Yeah. What you say? It's attorney-client privilege issue?
It's a fiduciary duty. It's a contract issue between the partner and the firm. You as a partner to the
Sorry.
firm.
Oh, yeah, yeah,
So,
yeah. The fact that I can't recruit clients while I'm a partner,
mhm,
that's correct because as an associate I can, right?
exactly.
If my partner is about to leave, I as an associate can start calling the clients and say, "Hey, I'm going to such and such. Well, what is Bob doing? Oh, I think Bob is coming too because we're all going together, right?" And so,
Yep.
hi Chinga. Did you have a question or are you here to harass me?
I came up to say I love you. No, I came up to say that I asked. I asked for access to that genetics outline, and I can't get it. So I don't know where it went when I asked for permission to get into the document.
All right, I'll send it to you again.
And then I
Not
have a
now,
question.
but once the room's over.
Yeah, and then I have a question, and it's sort of related to this. And I hope you do a room if you didn't already do one. So with Bayh-Dole and American Competes Act, I was at EW Madison when Jamie Thompson left and told the Wisconsin Alumni Research Foundation to go, suck it. And so like that whole story is interesting because my boss at the time and everybody else at UW decided that they would take things to a certain level, then move their operations across the street to an empty storefront with a telephone and an address, and then develop their intellectual property from there. So I mean, I know there's been a lot of different strategies to avoid the university claiming whatever it is that you made, but if you can do a room on that whole situation, that'd be interesting.
First of all, is there anybody who doesn't hate Worf? I don't think so.
Well, probably the
That's
people who work there love it.
probably. So this is the arm of University of Wisconsin, Wisconsin Alumni Research Foundation, which owns a lot of or owned. I don't know if those patents are still enforced or not, or if they have expanded the portfolio or not. I haven't dealt with them in a few years. But back in the day, they had this onerous licensing out policy on some technology that everybody needed. And so they were cursed up and down the aisle all the time. Jim, did you ever deal with them?
Never had to deal with Worf. I save
Yeah,
all
I
my.
didn't I didn't get involved with them directly, but Kenobi did, and I could hear people yelling and screaming.
Yeah, I save my love for the UC regents.
Yeah, they're next in
Yep.
line. So Chinga, yeah, that's the question that you ask is kind of is really open. I don't really know where to start even thinking about that question. It's like, well, so they don't do these things. I mean, what things? Mostly because the references that you made, I was unfamiliar with them. So maybe if you can clarify the facts a little
Well,
more.
I was just wondering how, in the corporate world, which you guys just all described, how that relates to the academic world, which is a little bit more squishy.
So my experience has been that the tech transfer offices of universities are anything but squishy. Uh, they're in fact quite assholes, and they throw their weight around because they know they can. It's a lot more difficult to negotiate a license with a university than with a company because the company is profit driven, but the university is greed driven. And so it's a lot more difficult. Licenses are a lot more onerous. Uh, so I had one really bad experience negotiating a license with a UC campus, which from the day the agreement was signed, they breached it. They breached every single term in that agreement, and there was absolutely nothing we could do. And so I hate them. So I much rather deal with corporations than with universities, especially public universities,
Oof.
because they have this chip on their shoulders that taxpayers paid for this, and so you have to, be really, really, really grateful that I'm giving you the opportunity to pay back to the taxpayers. And so, I mean, there's some truth to that. There's, yeah, but not to the extent that, in my opinion, not to the extent that they want to go to. Jim, do you, do you want to speak
I
of
do,
your
actually.
experiences?
Sure. I won't comment on technology transfer offices because, once again, I'm in full agreement with you. But Chinga, nice to meet you, raises an interesting issue about academics moving into the private sector, and where do you draw the line from demarcating the work you did at the university versus the work that you want to do in the private sector. Um, so so when you take all your pencils and you go across the street and you start working over there, that checks one of the boxes for IP ownership, which is, are you using the university's resources to develop that technology? And if you've gone off campus and you don't work for them anymore, then you can say, yeah, this is now my stuff, not your stuff. It gets harder, and particularly in the academic setting, because it if you're furthering the research that you were doing when you were at the university, it's likely, possible, probable that the work that you do independently um, will probably fall within the scope of an IP claim that was established while you were at the university. If you create if you create an invention, you invent something, and there's actual intellectual property around that. And then you go across the street and you start working on that stuff. Um, if the university pursues its rights and gets a patent, for example, you might be adding new bells and whistles to the original invention, but that invention may still fall within the scope of any claims that the university gets granted. And so you would own the bells and whistles, but you would still have to get a license from the university to practice the underlying technology. Does that make sense?
Yeah, but that's the squishy part, is that's if they know about it, right? I mean, so many people are doing so many things, and different labs and different buildings are sharing, some of the developmental parts of whatever it is. It's a bunch of different parts that come together into particular invention. For us, it was creating monoclonal antibodies in a specific way, and that's what he took across the street.
So that know-how and my practice was focused a lot on monoclonal antibodies. So I'm very, very familiar with that technology. Um, if the methodology was developed at the university, and then you take that methodology and you go across the street and you start optimizing it, you're going to probably run afoul of the situation that I described for you. Um, the point that I heard you make about, are they going to find out about it? My rule of thumb is, generally, if it's going to be worth a lot of money, the university is going to spare no expense to find out whether or not they have a claim on your technology. And so j- doing it under the table is probably not a sound business strategy, because the people, so you take your stuff, you go across the street, you make it better. It's still fundamentally the same thing, but now it's better. And in a fair open market, if the two methods were competing head to head, your new method would work better. And so you would win that competition. And so then you start a company to try to exploit that technology. The people who are going to give you the money to start that company, as part of the diligence process, they're going to poke at this very question. They're going to ask you, what did you take from the university? And you might not have to tell the university everything, but you definitely have to tell your potential investors everything. So it's going to see the light of day.
So here's an example. I was once brought in to solve a problem, and I ended up bringing in a team of attorneys and scientists who work around the clock to finally, we were able to kind of untie the knot. Here's the thing. Professor at university comes up with a compound that is in the lab active against proteins that cause disease X. The the university has a technology park which allows the professors to start up their companies in this park. It's an incubator space. And they provide, some startup funds, etc., for these startup companies. So the professor sets up this company in this building on campus, but in the technology park. And the people who work there are he has a whole bunch of soft money scientists, and he has postdocs and some grad students. So the people who work for the company are his soft money scientists and postdocs. What happens? What happens is that these guys only have one lab notebook. So, and some of the equipment they need is at the university, some of the equipment is at the company. So what the professor said is that I have this much startup money, I'm not going to duplicate equipment. I'm just going to fill in the holes of the equipment that I need using my startup funds for the startup company. And so they would make the compound here, then they would walk across the street to the lab in the university, do some testing there. Then they would take that data and the compound, come back to the company, do some other tests there. And they use the same lab notebook for all of this. And so the patent application was filed in the name of the university and was issued as a patent, but the company was going under. So the assets revert, some of it to the investors, some of it to the university. What goes to the university? The thing that the university owns. What goes to the investors? The thing that the company owns. Now, of these compounds, which one of them is owned by the university, which one is owned by the company? So we had to go through all the lab notebooks for the entire duration of the project, figure out what tests were done and the equipment that was used for that test, was it in the university or all at the company? And at the end, we came up with a set of compounds that were owned by the university, a set of compounds that were owned by the company, and a set of compounds that were owned by both. And so this situation became really, really bad for everyone, right? If at the beginning they had delineated the company and the university, the investors would have made out with a lot more money than they did. So what it was was that basically everybody lost money except me. I, I, I was the only one who got who got paid for his efforts. But yeah.
Well, I'll give the room a moment to respond before I respond. Okay. So Sam raises a beautiful issue here. Um, and, and that issue is you can't, it, it is not prudent to go into these situations with a head in the sand approach or a we'll deal with this if and or when it happens strategy. Because if there's money involved, the bad things are going to happen. And the prudent way to go forward here, as Sam just alluded to, is you talk to your friendly neighborhood patent attorney or IP attorney, licensing person, whomever, and let them imagine the worst case scenario and then work backwards so that you get the agreements in place before the money is being spent, while everybody's still bestie friends at the beginning of the relationship with the university, so that if the poop hits the fan, you know how things are going to shake out. So you have at least a plan on how who's going to get what and when. If you don't plan ahead, the only people who are going to make out like bandits are going to be the attorneys. Sam?
We yeah, absolutely. We operate under the assumption that Murphy's law is a fact. That if it can go wrong, it will go wrong. Because if I can protect you against all the foreseeable wrongs that can happen to you now, I have protected you against like 90% of the wrongs that can happen to you. But if you don't come to me, then as one of my former colleagues used to say, 70% of my job is to clean up the fan. If you had if you had called me at a time, I would have, told you how to put a barrier in front of the fan, right? So, but you didn't. So instead of paying me $400 at the beginning, you have to pay me $40,000 now for me to untangle the shit that you have tangled yourself into.
I would just want to add to that Murphy's Law. So I prefer Finagle's Law, which is basically the same thing. What can go wrong will go wrong, but at the worst possible time. And so anticipating this stuff ahead of time, this stuff is still going to go wrong, but at least you have a plan on how to get ahead of this stuff. I had a client who was working for a university and um, they innovated using the university's facilities and resources. And this university was a bad actor, was discriminating against this person. And um, at the end of the day, when this person wanted to leave the university, we got a great deal for them where all the old stuff still belonged to the university. All the new stuff belonged just to this person and the company, a clean line in the sand so that future diligence projects would be able to see that line of demarcation. And the university couldn't come back later and claim an ownership interest in the work that was done subsequently after this person left their employ. And we knew that the university didn't have the resources or the wherewithal to pursue the old IP. So all of that went abandoned. So that's a clean bill of sale. That's a clean slate. This person got to go off, start a new company, and doesn't have to worry about the university coming back to haunt them. And that's what you really want at the end of the day.
I have 3 points. Number one is the obvious point of if you want to deal with the university, I don't care what you want to do and what the university is. You want to sell them an orange, right? You need to first talk to a competent lawyer because it is hell to deal with universities. Number two, 2 points that Austin raised. Number one, Trump's contention with international students has many, many different factors wrapped up. IP issues is one of them. And then endowments are not, no, patent portfolios don't include, endowments don't include patent portfolios. Endowments are basically investments in the stock market. So the patents that the university has, they all go to the technology transfer office. Different universities call it differently, and they're put up for licensing. Yes, Chinga.
I want to apologize for taking you guys off track because yours was a very unique context, and I was asking for a future show about Bayh-Dole and universities and all that kind of stuff, and now things have muddled. But I admit I'm not a business person, I'm not a lawyer. I don't.
You cannot make Jim and I talk about things that we don't want to talk about.
I know. I'm just clarifying.
And if you'd ask a question, it's like, "What the fuck, Chinga? Can't you fucking figure out this is out of we both would have told you that, so don't worry about it. See, we're dressed the same. It's because we're the same people.
So
He's not wrong.
going back, so like in the corporate world, at least in my mind, if you are an employee or an employee, it doesn't matter how genius you are and what you invent, right? That belongs to the company. That's what you signed up for when you became an employee. With a university, it's a little bit more fuzzy. Like for me, I think that the university or company, I don't care how many resources they provided, you're the genius, you're the one that came up with the idea, you should get 90% of the proceeds or whatever. That being aside, in a corporation, like I said, you signed up for that. In a university, it's all mixed up. You get money from here, you get money from there. Some people, like you were saying, Sam, some of these are graduate students with soft money, some of it's hard money, some of it's incubator money, and it gets really confusing really fast. So, just from a rationality standpoint, what is the rationale? Other than the Bayh-Dole Act, which I don't like, what is the rationale that the university should get anything?
So 90% of, I mean, that's a lot of the majority of university research that gets patented is supported by NSF, NIH, or DoD. And so it is. So let's talk about public universities first. So a lot of the money that goes into the development of that comes from the federal government. The rest of the money comes from the university. They're the ones that are providing the space. They're paying the graduate students TA salaries. They're
5% indirect.
well, they're taking 45% off of your NSF, right? So yeah, the source of funding for a professor's project is both the federal government and the university. The federal government protects its investment by reserving margin rights in the patent, and for patents that are supported by federal grants, you see the first sentence says this, the research here was funded by NIH grant number such and such. The government may have some rights in this invention. And so that is when the government, if the government sees fit, the government can march in and take over the patent and tells you to fuck off. I don't believe the government has ever done that during the
Correct.
yeah during after 9/11, when we had the white powder crisis. Tommy Thompson was Secretary of Health and Human Services. He very briefly entertained marching in on Cipro patents, but he was quickly shut down by the captains of industry, and so that never happened. So that's what the federal government does. The university recoups its investment by having ownership in the patent and receiving a portion of the licensing fees. Did that answer your question?
Sort of. Do
Yeah.
do universities have trade secrets or something analogous?
Oh yeah, absolutely.
Yeah.
Everything that goes on in the lab that hasn't been published is a trade secret. Is considered a
Absolutely.
trade secret. Yeah, absolutely.
Absolutely. Yeah, when you, Chinga, I'm going to try to answer your question. But first, just to support Sam here, when you go to a research institute and you are a visitor, you have to check in, you have to sign a log. These days, you probably have to have your picture taken. All of those steps are to protect the confidential information that's being generated in those labs.
If you walk on UC San Diego or UCLA or whatever campus, and you want to go into the chemistry building, you get in on the first floor. That's where the professors hold their office hours. But you can't get on the elevator to go to the second floor unless you have a badge that you can badge in, and then that shows exactly who entered the building at what time
Yeah,
and where did they go.
exactly. All right, let me go back to try to answer Chinga's actual question, Sam. Um, so spiritually, philosophically, uh, you might, and it seems to me from what you said, you see a difference between industry and academia and how inventors' rights are treated. Is that fair? Am I putting words in your mouth, or is that fair?
Oh, that's fair, especially with the whole trade secret thing, because everybody and their grandma comes into the lab and learns those trade secrets. What are you gonna do? Follow around an undergraduate student and kick him in the head if he says something?
Well, exactly. I mean, the principle is still there. The enforcement isn't, because the threat level is so much lower in the academic space, and because of the nature of academia, that stuff is going to get out sooner or later. It's not a question of if, it's just when, because that's what academics do. That's what basic science or even applied science is about, is moving the ball forward, and you have to tell people about what's going on. But fundamentally the protections are still there, and trade secret does still exist. But back to your original question, I hate to break it to you, but there is no legal difference between selling your soul to a company versus selling your soul to academia. There's still a sale. When you become an employee of the university, you sign an invention disclosure agreement. You assign all of the rights to any inventions that you make while you are an employee of that organization. It's exactly the same thing as a company. The differences come in when you start looking at how you're compensated for that work, but the fundamental relationship between you as an employee or indentured servant if you're a graduate student and an employee at a company, I don't see a legal difference.
There isn't.
I have a question related to that.
Go.
What happens to the IP if there is a relationship? There are agreements, and there's compensation, but the compensation fails. The compensation is not paid.
In the corporate setting or the university setting?
Corporate setting.
What is it? Okay, so what do you mean by fails?
So the compensation is not delivered.
So I have a company and I hire you to invent widgets, and you invent said widgets, and we go to market and we make a shit ton of money, and I breach the employment agreement that you signed where you were supposed to get a 50% bonus if we start making real money. You sue me.
That seems like it. That seems like it would do.
Yeah, exactly. You sue.
Yeah,
No,
that's
no.
a
Well,
straightforward breach of contract case.
Exactly.
It has.
what is the case where the company goes bankrupt?
Then you go into bankruptcy and you file a claim as a creditor, and then you wait in line to see what the bankruptcy
Right.
judge does.
Yep.
Yeah. So who owns my IP work during the period between the time that I invented and the time that I'm paid for it
Uh, Whoever
as a
you assigned
contract?
it to,
As it, well, assume there was no assignment
then how do they own it?
because they have agreements. Let's say they
No,
have
no, no. So
agreements,
they have
an
a
employment
right to
agreement, something
own.
like,
Yeah, they
yeah,
have a right to own, but they don't have actual ownership. They
Mm-hmm.
still have to go to
interesting.
court to enforce their right to own. They have to go to court to force you sign the assignment document.
Yep.
Right.
So try this one
Interesting.
out for size. You're working for a company. You have an employment agreement, so you get paid, but they don't have an assignment agreement. So they don't own your IP per se. And you, so when you're at work, you're using their test tubes, you're using their pipettes, and you make something. You take pipettes home with you and you do work out of your garage that's very similar to the work that you're getting paid for. But it's off the books, and it's not exactly what you're doing, but still pretty similar to what you get paid for. If they don't have an assignment agreement from you, they have to come after you and show that um, this was within the scope of your employment. You know what? I don't love this. I don't love this hypo. Let me try to save this. If you don't have an assignment agreement, the company has to work harder to show that your intellectual output belongs to them. If you do have an assignment, it's much harder for you to show that your garage labors are yours and yours alone.
Fair enough.
Yeah.
Well, I was gonna bring up the before I got disconnected. The if this is still relevant as well, the Omega, optical and what was it, Chroma Tech case. That then that so that demonstrates a lack of reasonable security measures, right? Uh, it can doom a trade secret claim. So So what? Right. So what specific protocols should companies use? You think to meet the reasonable efforts quote standard?
Yeah, that's a very good question, and I ask you to tune in
Oh, okay.
next week
Oh,
because that's the subject of the room next week. Is what are the measures that people can take to show reasonable efforts, and what are the provisions that should go into an NDA uh, in order to do that, and then provisions for the NDA is a good segue to start a patent conversation because, uh, in my opinion and many other people's opinions, the purpose of an NDA is not to protect your trade secret, but to protect your invention from being publicly disclosed for patent purposes. So that's a much more important part of an NDA. So that kind of allows us to go into the discussion on patents.
okay. So something to look forward to. Okay, thanks.
Hey, Sam, just a
Hi,
quick
hi,
question.
Io.
Yeah, so what we got with some of the work that we did, we used something called a participation agreement, which is like I guess, an interesting kind of precursor to what you guys are talking about. If you've already mentioned it or commented on it, it's okay, we can move on. But if you have any comments on it in regards to what we're discussing now.
What is a participation agreement?
So,
What goes into it?
yeah, so basically it like states, so kind of like what Benjamin was, I guess, should have had before you start assigning any IP, like everyone's participation is clearly outlined and to what extent they have responsibilities and what they can disclose. So even before assigning that's something that we did, but we should have had a stronger one. So some holes were left there that like for example, being able to publish without the other team, for example, being okay with that, like we recently saw with the Korean room temperature semiconductor. You had a difference of opinion of the research teams, and one of the teams basically decided to go rogue. Similar case here, they decided to go rogue and publish anyways. And it's weird because IEEE won't take down the paper. So it's kind of odd how like things are sometimes in favor, even if you have all of the like the internal investigations from the university and other things like that showed kind of our case, but something stronger than even a participation agreement is needed before you even get into the negotiation of who owns what.
Yeah, we normally in the life sciences area, we deal with these as part of joint research agreements or joint development agreements between the two companies, because once the two companies or the company and the university get involved, there, there are a lot of things that need to be worked out as to this relationship. You know, as you said, who's going to do what, who does what test, who uses what equipment, who pays whom what, and then it defines what you know, party A's discovery, party B's discovery, joint discovery, what those things are, how those are determined, and then based on that, you define what the party A IP, party B IP, and joint IP is going to be. So as you said, yeah, those are negotiated and signed well before
Which is
any work
crazy
gets
because
started.
how can you know that before you've done the work, Sam? You know what I mean? It's like I'm only gonna invent this. And then, oh, this is what we thought in, like, it was this in my garage, that's kind of like the example. It's like if I made it in my garage, Is it a joint participation, or can I, you know what I mean? So just those kind of things are annoying to hash out if you've never done this before as well. So for students, like I went into this never having done anything business, and just the incubator kind of tutored us up to, you know, hey, here's the literacy that you need with respect to intellectual property law. And still so many things fell through the cracks. Like they had like a really good system, and it's still, you know, a knife fight in a phone booth. That's what it became.
Well, it's because if you knew how to do this, then there wouldn't be a work left for me. And so we
Oh,
try
so this
to
is about
keep it
jobs.
away
Okay.
from you. So we feel important to come and tell you what you can and
Nice
can't
cheeky
do.
answer there. Nice, nice.
Yeah,
That
that's
was
all.
Troy
Thank you.
Sam. That was a great question. That was so much fun. When I teach to academics and I tell them about the business of IP law and biotechnology, I liken it to being Levi Strauss during the gold rush. Hey brother, you're gonna go dig in the out there and look for gold, and yeah, you might be. I'm getting paid on every pair of jeans I sell. I get paid no matter what. So, yep, Sam's right.
Oh yeah. A lot of people say, you know, do this work. We're going to give you shares in the company. Uh-huh. Uh-huh.
Oh,
It's like, no, thank you. I'm a lawyer, not an investor. So
yep, yep.
no.
I do
Don't.
that work. I just call it charity. Mm.
Yes. I've told you the story of we being Dana and I worked for this one company out of Boston. It was were you at Kenobi when Orexigen was there? Orexigen Therapeutics. I was doing their work. Yeah, you were there, but we didn't overlap with that
I've
client.
erased all of that. I've
I
erased all of
know.
that for him. And
Anyway,
for the room's benefit, Dana is, I think, a former law partner of yours. Is that
yes,
right?
at
Okay.
Tekla. Yeah, he's a trademark attorney.
Yep.
So at Tekla LLP was Dana and I, the evil Satan who came and broke everything. Anyway, uh, so Dana and I worked for this company. It was former executives at Orexigen who had gone there, and we did about $37,000 worth of uh, legal work for them. And they gave us these options, 37,000 options at $0.001 each. And we're like, all right. Well, what happened was that they did so many inverse splits that they finally bought us out at $17.50. And so we went to Starbucks and got two really fancy coffees. So that's what happens when you accept shares from your clients in lieu of cash. And
That's
that's my
literally what I'm doing right now. I'm doing that calculation. I'm like, okay, how much do I have to dilute to
oh, yeah. Well, it was because, you know, it was like $100,000 investment when we first came in, and then it was like $50 million when they bought us out. So I was like diluted to $17.50. That was yeah. Debbie said, don't cash this check. Just frame it. And I'm like, no, we need to have something, tangible profit out of this. And Starbucks coffee is a Starbucks coffee.
Nice.
so,
Nice.
so don't take investment advice from me.
I have a question, if I may.
Please, yeah.
I'm a medical scientist, and I received my training in major institutions. Recently, I came up with a model, AI for precision diagnostic tools uh, for a pharmaceutical company. How do I protect my intellectual property? I did
Is
it while I
this
was doing it, uh, my studies at a major university. So
where
really,
you're,
the pharmacy. I'm sorry.
was this related to what you were doing?
No, this is it definitely has a serious, significant value if they implement it, which they do
No,
want to
that's not
implement it here.
important. The question is whether the subject matter of this thing that you've invented is related to what you were doing for the institution. And this relatedness, you have to take that as broadly as possible, meaning that if you were working in medical research and this is an AI tool that facilitates medical research, even though that research is not what you were doing, that is most probably related.
Yes, it is
But
related, of course, but
yeah,
the thing
okay.
is, the research was done at the university.
Oh, okay, yeah.
Uh,
So it's not your intellectual property, it's the university's intellectual property.
Yeah, it might be like go through the lab to see if they had already agreement with it.
Yeah.
the
And
thing,
Because you belong to the professor, and the professor like to the university, and then the university is like the juggernaut that usually bullies you around. So be careful.
yeah, you have to look at what kind of agreement the
we didn't
lab
sign an agreement.
has.
That's the thing.
No. What kind of agreement the lab has with the university, what kind of agreement you have with, I mean, you said institution. I don't know if it's a university or something else, but what kind of agreement did you have with the institution? And if there's a third party company, what kind of agreement exists between the university and the third party company? I wouldn't be so quick to saying there was no agreement, because a lot of times the people who negotiate the agreements are not in the lab. They're even the PI is not there, right? It's the company and the tech transfer office that are negotiating that. So yeah, that's all.
Well, I have a background in business too, an MBA. So what I did is monetizations of patents because that's what really matters. It has a significant value because that can speed the process of designing new drugs substantially. So there is a lot of stakes here. Uh, no, the company has nothing to do with the research. The company, when they learn, they definitely want to use it or bring it. No,
Uh,
definitely, I would need to consult with
yeah,
expert and specialist in this area.
yeah. I mean, as I said, it's I would say Jim and I are both experts and specialists in this area, but we don't have the facts.
Oh,
I
I
haven't,
understand.
I haven't
I'm in
seen
Southern
any of the
Nevada.
agreements,
No, you're not.
Where are you? I'm in California Bay Area.
Yeah, we both, our practice is in San Diego.
Oh, okay, San Diego. Yeah.
Yeah, so we don't have the facts. We haven't seen any
No,
of
no,
the
I understand, and I'm
agreements. We
not
don't
asking for
know what it is that
professional
you
or
did.
legal
But
advice. This is just an educational.
Yeah,
Uh,
a lot of times what I advise my clients is uh, get the university's blessing ahead of time. That is, send something to. Uh, I like to hear what Jim thinks about this.
I agree.
Uh, that send a letter to the tech transfer office and say, this is a research that was done uh, under these conditions. In my assessment, the university doesn't have any rights into this. If I don't hear back from you in 30 days, I assume you agree with me.
I agree. I think that's perfect. I would talk to your advisor or wherever you are in the academic chain of command and make sure that that person knows that you're going to do this,
Yeah,
because they may have more facts, and also that's just good politics. You don't want to make trouble for your boss when a simple conversation ahead of time would prevent that. But what the purpose of Sam's
I
letter
graduated already, so
no, it doesn't
that was
matter.
the
It
work.
doesn't matter.
Yeah,
Whoever the PI was that you were
exactly.
working under.
Like
Yeah.
In
somebody
fact,
else should
might
be doing the work too, right now. So like you'd have to establish that chain of custody for the history of it.
yeah, all that stuff. Um, absolutely. And so the purpose of Sam's letter, so you talk to your former boss, and it's all cool, and then you send the letter, and then you get radio silence, and the date passes. You put them on notice. You gave them an option. They decided not to avail themselves of that, and so that is a great way to argue that you own that stuff free and clear. Um, the likelihood of that happening is pretty low. They will get back to you. And at the end of the day, you would want them to assign their rights to you so that you could go forward. That's the gold standard.
Yeah, we
Yeah,
had that
and
happen in our case, and the professor not only told us that, like we were the company working with them, but they were like, "Hey, if my student messed up, then fire them. Don't give them." Like it was like, wow, that's really weird. So there's something like academic honesty that goes a long way. Obviously, it varies from institution and varies between professors, but that was at least our experience that before the heavy legal stuff got involved, the professors were like, "Hey, I want to make the right choice," and so that was
Right.
kind of nice.
Yep.
good thing Benjamin isn't here to hear about academic honesty.
Oh, classic.
yeah, research nowadays at major institutions or everywhere is a nightmare because of short of funding. So they're really desperate for anything.
Yeah, and so what that does is that it increases the number of funding agencies throughout the life cycle of the project, which then that confuses the ownership of the IP that comes out of that. If you're just dealing with the NSF and the university for the whole life of the project, then at the end it's clear
It's
who the
really
owners
based
are.
on a research paper. That's it. But then the concept was developed during this, so there was very little usage of the materials uh, or resources of of the institution. It was mainly an pure intellectual development of the concept. At
Yeah,
least,
so that's as we will find out on the first day of the patents uh, uh, lecture or rooms. I'm going to talk about the case of Ethicon v. U.S. Surgical, which kind of goes through and talks about what the criteria for uh, being an inventor uh, is and what is an invention. And so just a lot of times just developing the intellectual aspects of it is sufficient for that, for you to have, for the person who developed it intellectually to basically have created a complete invention without having an actual reduction to practice. Reduction to practice is not necessary.
Cool.
the thing is nowadays because of all this AI, it is a wild, wild west, but it's also a great opportunity for invention. So
Yeah, I'd like to see where this AI thing goes. I don't know where it goes. So, uh, you know, uh, uh, a lot of things were predicted to be a lot of things as technology came on board, and some of them proved to be much more than anybody could predict. Some of them fizzled, and so as a general rule, I'm going to kind of hold my judgment on this AI thing until and you know that's kind of like thinking like a lawyer. They say, "Whoa, what do you think of this statute?" Let's see what the courts do with it in a few years, and then come and ask me, because right now it's just a statute. It doesn't mean anything. So that's my response to AI as well. Let's see what the economy does with it, the industry does with it, the courts do with it, the legislature does with it, and then I'll start to panic.
Oh,
that
I've never agreed with you so many times in one conversation, Sam. It's kind of scary.
the problem with AI and regulatory, there is not really much. If you look at the FDA, they are struggling now. Is it a device? Is it a drug? Is it a biologic? What is AI? So there is a problem for
Yeah.
defining AI. How do you regulate it?
Well, all of these problems with the FDA will be solved after Kennedy dissolves the FDA. So we're not gonna have any problems with the FDA anymore. Isn't
Oh,
that great?
yeah.
That's
Okay.
amazing. That's like when we ask China about the concentration camps. They're like, we don't call them concentration camps, so we don't have that problem.
I know.
Oh, go with the experts. Excellent. Okay, I gotta go, guys. I really enjoyed this. Thank you so
Well,
much.
Yeah.
thank you, gentlemen.
Yeah, actually, it has been going on for about 2 hours. So I'm also going to uh, kind of close down the room. I moved away from my computer, so I have lost the ability to play a song, and I'm not going to sing for you a cappella. So,
I can do
are
it.
there any? Are there? No, thanks. Are there any questions? Anything for us to discuss before we
Oh,
sign off?
I think Plutos wants to say something, but I'll go after him.
Oh, okay. Go ahead, please.
Oh yeah, the other thing that you said you got away from. So okay. So another question might have been in the Intel case.
Uh-huh.
With the Latin maxim, knowing before, like so how should courts, determine the mental state of, required for use versus what was that, acquisition, of trade secrets, and should trade secret law, adopt, different, you know different standards, for different types of uh defendants, like individual employees versus corporate entities? If that's kind of a long question, though. I don't for the end.
So I think to answer the first part of the question, uh, the plaintiff in the case, that is the person who holds the trade secret and says the other guy misappropriated my trade secret, the plaintiff has to prove the defendant's state of mind. So, for example, they should show an internal email that, I don't know, the CEO asks the chief legal officer, "Hey, are there any trade secret issues here?" And the chief legal officer says, "Yeah, we're going to be violating trade secrets." And the CEO says, "Fuck it, we're going to do it anyway." So if you have something like that, which you never do, right? People in business aren't that stupid to have email conversations like that. But if you have something like that, you say here, knowingly, right? They knew they were doing this. But a lot of times, what you get is an email from CEO to the chief legal officer. Hey, are there any trade secret issues here? He says, let me look into it. Comes back and says, I looked into it. There doesn't seem to be any trade secret issues. Well, if the lawyer was wrong, now it's a negligent misappropriation. And so that doesn't count as misappropriation because you have to have knowingly done it. You didn't know, you thought you're not doing it. So, uh, you need to have enough evidence, either direct or circumstantial, to kind of show prove the state of mind. This is not something that's unusual. Every criminal case has the state of mind portion to it to show what the guy was thinking at the time. A lot of this knowingly or intentionally, or that comes up in a lot of different laws. For example, have you breached the contract? The answer is, well, yeah, the breach is a breach. That's objective. But, well, what should the damages be? So now the question is, well, did you knowingly breach it, negligently breach it? All of it. So the law and lawyers are very comfortable in determining mens rea for different things.
And it helps, as you said, to have like one thing that we did was we reached out to like the university lawyers. We spoke with like 3 different lawyers from the departments. We spoke to the dean. Like there was just like a lot of things where if you leave that much information, if you're doing things in secret, it kind of sucks. So part of that is kind of what happened with the pandemic. Like access was restricted to the lab, so that was an interesting thing that we had to navigate. But yeah, that's kind of like the probably the most important thing that I wish I had done more, even though I did it very extensively. So
Well, I mean, the university also has to untangle their legal rights and duties because
yeah, they threw
base,
the professor
I
under the
mean,
bus.
they have
So
agreements. I mean, they have agreements with the funding agencies. And
yes,
so
yeah,
whatever they do to you has to comply with their duties to the funding agencies. And so,
exactly. Yeah, they just threw the
so,
professor under the bus. That's what they did.
uh,
Yeah, crazy.
yeah, you
And
usually figure out who's the most dispensable person, and then they
yeah,
take the blame.
yeah, and unfortunately, here's the other thing. Like, unfortunately, the director of the lab, who was kind of like organizing everything, he passed away. So it was like the only things that were left were a few of his emails and stuff. But a lot of the conversations that happened in person about the details and so on were uh, conveniently inaccessible.
Oh,
So yeah. So, but anyways, I'll leave it there for now. Thanks.
okay, guys, I'm going to sign off. And I think Shamash is still in radio silence. No
Yeah,
philosophy room.
yeah, we're
Yeah.
still on break. Still on break,
Okay.
unfortunately. Yeah,
We
I
look
can.
forward to you coming back.
Thank you. I can play the room out if you like.
Yeah, that would be great.
All right.
So just a reminder also that this coming Thursday, 2 days from now, at 2 o'clock Mountain, 1 Pacific, 4 Eastern, is the chemistry round that we're going to be talking about ions of carbon. All right, everyone. Thank you very much for joining me today. And I hope you all have a great rest of your day and a great rest of your
week. Take care.
Take care, buddy.